Honestly, Commissioner, when I was told sample writings, this is my first time I'm appearing for interview. It never crossed my mind that I'll come here and be asked in this writing. I would have slept for 1 week and picked what I think would have been ideal. But when I was told sample writing, I thought you would just come and look at them and say, is this judge within the parameters of judgments and whatever.
So you're saying these are not your best?
No, I can't say they are my best. Whatever judgment you write is your best, but there are those ones you say, these ones, it's like your clothes. All are your clothes, but you have your Sunday best.
Okay. So anyway, before I proceed on the sample writings, I just want to follow up some of the one or two issues that were dealt with by my colleagues. The first one was the issue of perception, because in administration of justice, perception plays a very important role. That's why we say justice must be seen to be done. And I don't know whether I got it right, you actually said that perception is a problem that cannot be settled. That was your statement. If you look at if you've read the strategic plan of the Supreme Court, one of the threats they identify, and I believe that goes for the entire judiciary, is the threat of shifting public perception that is not based on facts and distortion of facts. My colleague Commissioner Warsame also mentioned it. This issue of perception that the judiciary is corrupt or that the Supreme Court is not handling matters well, and is a threat to independence of the judiciary. Just give me some ways in which you intend to deal with that issue of perception so that the public continues having confidence in the judiciary.
Thank you, Commissioner. I think perception can be measured in this scientific era. If you send out questionnaires to the members of public and ask them about corruption in the judiciary, they will give you answers today. 6 months down the line, you send similar questionnaires. You can quantify whether it's improving or it's decreasing or accelerating. So perception has been there, and we have come out from a very bad perception when judiciary was viewed as an executive arm to the current position where judges have been able to write their minds, even if the orders are not effected, ignored, but you have said. So perception, as you say, in the Supreme...
So what I'm just asking is, what would you do, what one or two things you would do to improve perception so that it is positive, so that we don't have an issue where the confidence of the public is undermined?
Okay, with the strategic plan, the first thing I will do is to enhance communication from the side of judiciary. We have been doing good things. We have been delivering judgments even in this COVID era. But the communication which goes out to the public, it's not there. The communication aspect from the judiciary, and we have said this time and again, that there is need to communicate to the public what we are doing.
Okay, that is the first one.
That is the first one. The second one, we are dealing with perception, or if there is, now we will go to the specific aspect of the courts, as you are saying. There is that perception that there is corruption in the judiciary. That is also perception. You have to come up with policies how to tackle corruption. I've seen the causes of corruption. We have had many committees formed to deal with these issues. There is no need for me to say if I become the CJ, I will form a committee to go and evaluate why do we have corruption in the judiciary. That is not perception. It's real and it's perceived. So I will deal with the general aspect of the work of the CJ will be to communicate to the public so that that perception, and not only the CJ, but each and every judicial officer, including a judge sitting in the Wajir.
Thank you, my lord. Now, you actually took, you knew this issue of Martin Chara was going to come up, and you're aware that it's an issue of public notoriety. It has been the subject of complaints, and I believe you have answered. That case, in that case, you said, in fact, we agree with you that, in fact, there are defenses in certain instances, which is what you said, isn't it? Now, the problem of the notoriety of this case is that it has been termed, and that it was the worst judgment, according to the Women's Link Worldwide Bludgeon Awards, because it failed, the comments that were made therein, made by a judge, and courts have strong influence on the sense of justice and the daily life of people in countries across the world, whatever their political system or religious traditions and beliefs. So what they were complaining about is not so much that there is a defense. They are saying that it is the manner in which you communicated your sentiment. That was the complaint. It's not even that the decision was right or wrong. Yes? That is the complaint. You have talked about communication. Now, in your own view, the way you communicated this decision, is it something you have reflected on?
The way I communicated in that decision, I will communicate the same. And the idea is to also to communicate to the public that whatever is happening, it's not something to shy away from. So that we come with moderate, soft words. One thing I'll tell you is when I write my judgment, I'm not considering what the judge of appeal will say. I'm dealing with the problem as a judicial officer independently. And if another person feels that I use strong words and criticizes me, I'm ready to be criticized. That's why we are judges.
Yes, we are ready to be criticized, but isn't there an obligation on a judge, and you will be the Chief Justice writing judgments, isn't there an obligation to communicate to the public clearly without leaving a situation where somebody who is marginalized feels that you are not giving due attention to the situation? And I'll read for you what you said, and I'll read for you. You said, it is important to distinguish between law and morals. It is the law that a child below the age of 18 cannot consent to sex, which is true. Section 8.5 qualifies the provisions of Section 8.1 and 8.4, which penalizes defilement. It can easily be concluded that it is immoral for one to have sex with a child under the age of 18 years. However, where the child under 18 who is protected by the law opts to go into men's houses for sex and then goes home, why should the court conclude that such a person was defiled? In my view, that cannot be defilement. The complainant normally does not complain, but is made to be the complainant because she is 18. My view is that such a behavior is that of an adult and not a child. Children are not meant to enjoy sexual intercourse. Whenever they do, then that becomes the behavior of an adult. Although the public will frown upon an adult who engages in sex with a child, we should not forget the circumstances have changed. Young children engage in sex at a very young age. This is not out of defilement. conviction of a defiler should be based on actual circumstances and proof that the complainant was indeed defiled. So basically, when a person reads this, they say, you as a judge are saying it is okay and a defiler should be let free if a child behaves like an adult. And it is something that, should not be discouraged. That is what the complainants are saying.
Everybody will complain, Judge and Commissioner. Sorry to call you Judge. As I've said, everybody has his own interpretation of what you say. I believe I used very polite words, and I was picking from what the complainant said. If you go back, the complainant, I will be very honest, the proceedings before the magistrate court, that complainant said, I went to this man's house to have sex and I go home. That's what that lady said.
Now, of course, that is different from your other decision. There's the decision of you gave the decision, the Council of Imams versus Attorney General. And in that case, you are very, very clear that whatever the cultural, religious, social issues, child marriage is illegal and it cannot be permitted, isn't it? And in fact, you are very firm. There was no equivocation on your part.
And if you will allow me 2-3 minutes, these are two distinct cases. The first case deals with the defilement of a 14-year-old girl with a man that have been together for 3 years. The second one, it's a deliberate. You get a 16-year-old girl, marry her off and say the Islamic religion allows somebody to be married at that age. So distinctively, if I am to say it's true, because she was 16, she agreed to be married there, because the problem in the second case was these people had been charged in a criminal case, and now they came to me saying the charges should be quashed because this lady was 16 years and she agreed to be married. The parents gave her to get to be married. Can I say that truly at 16-year-old you are not being defiled, you are being married, and the law should encourage that? I can't say that.
Yes.
And that's why I came up and said, you go and face the criminal cases, and it is not possible. The law does not allow that. Turning now to the other one, here we are with the people who are friends, and now it's not a marriage. This is a friendship which has been subsisting for over 3 years. The facts are clear there. And in my mind, I was saying, surely, I can smell defilement from very far. The moment I read the charge sheet and the evidence of the complainant, I will know this is defilement. But there are those gray areas where you can see, surely, if the law should serve the society in this situation, do we have a defilement? Thank you.
Mm-hmm. Okay. So the problem there is really the issue of communication, and I just wanted you to tell us, in one case, any women, children looking at both cases, how do they perceive the issue that the law protects them in terms of the kind of issues they face today, sexual harassment, sexual exploitation? How is that to be communicated as a judge who knows that this is a very serious issue?
Okay, I'm getting you, Commissioner. Everybody has his own style of writing. I believe maybe somebody else will say, if I was the one, I would have written like this, massage the paragraph, say how did this lady fall into this and that. So to me, as you have said, it was deemed to be the worst. Where was the competition done? It doesn't bother me. Who came next the following year? Why haven't we heard of another one? We have just heard of that. When was it remitted for competition? Who assessed it? So the following year, who took the trophy? So those are things which, as a judge, does not bother me.
Okay.
But communication, you have said, on reflection, I think I did my best to deal with the case at hand. And I can tell you for sure, despite all these olabalus, the number of magistrates who have called me to say you have freed us from these shackles of Sexual Offences Act are many.
Okay. Next question I wanted to ask, and it follows up from what my previous commissioners talked about. 10 years of any institution is a time for reflection. And as a judge who wishes to join the Supreme Court and be a leader, you have reflected on that court, you have read its jurisprudence. And one of the purposes of the Supreme Court is to develop rich jurisprudence that respects Kenya's history, traditions, and facilitates social, economic, and political growth. In your view, has the Supreme Court succeeded or failed in this area? And whichever is your answer, give us one or two cases which you think it has succeeded or failed.
Thank you. I do agree that the Supreme Court, being the apex court, should develop indigenous jurisprudence. In my view, it has succeeded. That is my answer. It has succeeded. There are quite a number of judgments coming from that court. I think Commissioner Warsame talked of arbitration. I believe he was referring to the Nyutu case versus Airtel, where the Supreme Court held that although the Arbitration Act seems to restrict appeals, where in certain situations an appeal can be made to the Court of Appeal if the award by the arbitrator and the finding of the High Court seems to be enhancing injustice. There are so many other cases. We have the Murwatetu case. This is one aspect of the sociological aspect of the law. The law says the death sentence shall be the punishment for murder. The Supreme Court did not outlaw the death sentence, but in its wisdom came up with the idea that it should not be mandatory, and that is a good aspect of the law. In their wisdom, the Supreme Court nullified the presidential elections, and I was reading this judgment from Malawi, which nullified presidential elections there, and they were quoting the Kenyan case.
Okay, just to go to the Nyutu case, one of the criticisms the Court of Appeal has faced from time to time is the issue of expanding jurisdiction. You've heard of that controversy. But in the Nyutu case, it even goes further and expands not only its jurisdiction, but the jurisdiction of the Court of Appeal. What effect do you think that has on administration of justice and certainty of legal procedures?
Okay, we have to look at this Nyutu case from the perspectives of arbitration. Arbitration is different from mediation. In mediation, the parties even sign that they're satisfied with this decision. Arbitration, we agree to go to an arbitrator. And I can say for sure I do agree with what the Supreme Court said. If the decision of the arbitrator is taken to the High Court, it's either approved or set aside. And the law wants it to be stopped there. It's true there should be finality of decisions, but can we say that the arbitrator and the judge, their word should be final? Can't we reopen it up so that 3 judges of the Court of Appeal can evaluate this issue?
But isn't that the same position when parties enter into a contract? They agree that, you know, this is our contract. If we disagree, we want a sense of finality irrespective of what other people think. Because they've already a priori said, we agree to be bound by this contract. So what business does the court have saying your decision to be bound by an agreement is no longer final, when in fact when you contracted you knew that the statute under which you are contracting gave it some sense of finality?
There is that sense of finality, but okay, even in mediation, the one who signs maybe will unwillingly sign because he went there. And even in arbitration, definitely not all of them will be satisfied with the arbitrator's decision. But in my view, you know, when you are dealing, you can say so if you are dealing with an issue where you cannot read and say, I know even the Supreme Court decision, which is final, can be criticized and say this one, the Supreme Court got it wrong.
Actually, the law draws a balance between finality and your sense of justice. So now we have a problem because the Court of Appeal has said, or the Supreme Court has said, you know, if this decision is wrong or it is exceptional circumstances, and you sit in the civil division, and one of the things we were told, for example, the BPRT, the High Court is the final, isn't it? An appeal, there is no appeal from BPRT, there is no right of appeal from BPRT to the Court of Appeal. That's why we used to sit 2 on appeals of BPRT, although that no longer happens. So does that mean now a decision of the BPRT is appealable to the Court of Appeal? Because the Supreme Court has said, you know, there are certain circumstances under which you can appeal, irrespective of whether there is a right of appeal or not.
It will all depend on how the consumers of these decisions will do. If somebody comes before the High Court or the Court of Appeal and say, I've been before the BPRT and the decision of the High Court is against me and seems to be final on the strength of neutral, I would like to reopen this case and litigate before the Court of Appeal.
So you agree with me that
yes,
there has been a sense of uncertainty brought about by the Supreme Court itself?
I do agree.
Okay. Now, next question is, you talked about public interest. Part of the jurisdiction of the Supreme Court in civil matters, what is the jurisdiction of the Supreme Court in handling civil matters?
The jurisdiction, there is, I can highlight, there is the jurisdiction to hear the election petition. I believe that is a civil matter, quasi-civil, but it's a civil matter, presidential election. And the next one, there is the advisory opinion, which is a civil jurisdiction. We have the appeals from the Court of Appeal and tribunals. I have not seen an appeal from the tribunals going directly to the Supreme Court, but there is the jurisdiction to deal with appeals directly when they deal with constitutional interpretation. If it's a matter dealt with by the Court of Appeal involving interpretation of the Constitution, an appeal lies as of right to the Supreme Court. On the other aspects of the jurisdiction, it's a matter of public interest, and I think the Supreme Court has dealt with that.
Now, just on that small issue, you said public interest. I think the word used there is of general public importance. What to you is the difference between a matter of public interest and general public importance, and how would you distinguish the two?
Public interest can be compartmentalized. You can dissect it, because you can have NGOs coming in the name of public interest, but they are serving their own sectional interests. General public importance is wider. It covers, as you read this issue, it seems to be affecting the general public, like BBI. If an issue is presented before the Supreme Court relating to BBI, having come all the way from the High Court to the Court of Appeal, it will be a matter of general public importance. So to me, public interest is narrower compared to general public importance.
And what is the test? What is the test in your view? How would you distinguish the two? Because that is where the meat of the Supreme Court jurisdiction is vis-a-vis the Court of Appeal. How would you distinguish the two?
The short answer to that will be, it will all depend on the issue itself and the objective interpretation of the court, because I cannot perceive an issue and say this is general public importance. For instance, if it's a nationwide issue, which is the concern of the general public, like I'll give an example, like if an issue, somebody was to say Kenya should no longer borrow from the IMF or from whoever, and goes to the Constitutional Court, and an appeal is taken to the Court of Appeal, that is a matter of general public importance. That is an example.
Any cases that come to mind?
I'm giving because there isn't. I'm giving an example that.
I mean, because yes, what I want to know is the test, because part of the complaint you will hear out there is that the Supreme Court came to solve all our problems, isn't it? That why do we have a Supreme Court, yet it is not hearing our issues? So 164 has said, no, we are not dealing with everything. We are dealing with issues of general public importance as opposed to public interest. So one of the things you will be dealing with on everyday basis is, how do we distinguish these two streams? That this one, go home, it is public interest, but not general public importance. And this one may be of general public importance, but the public has no interest.
There is no one answer to that. I will lie to you to say this group of cases belong to general public importance, and this one, because it's initiated by lawyers or by an NGO, it's a matter of public interest. Okay. It will all depend. My answer is this. Honestly, it will all depend on the problem itself.
Okay. There are many decisions of the Supreme Court on that. Next question, and just as I'm finalizing on this aspect, one of the issues that concerned me when you were starting, and this goes, you've talked about a backlog and dealing with backlog, and thank you for exposing some of the problems we face. One of the issues you said that, which I caught, is that you worked yourself to the extent of becoming a diabetic. Now, my concern is this, room 17, you are holding 5 hats. What fear, should I fear that those 5 hats will cause you to aggravate your diabetes? And what is it you will do to prevent, to avoid this kind of situation?
Okay, I think the bigger problem is the induction. When you are inducted, that time you are not warned against overworking yourself. And that is a bigger problem. I think some of the committees came up with the issue that newly recruited staff should be inducted. I'll give you an example. On a Thursday when I had a confirmation of grants, I would sit from 9 to 3 without even taking a break. I've learned my way in the judiciary that you need to take a break after maybe 2 hours. And the many hats, these many hats will not come when I'm just seated in the office doing the work of many hats. You'll have to go out, interact, you have to come for a meeting and deliberate on issues. So it's not an issue that one has to do this work whether you are diabetic or not, whether you are epileptic or not. Those are conditions which are there. But I've learned from the hard way how to handle these many hats. That time, I think I was overworking myself, no exercise from the office, to go and sit and write judgments up to maybe midnight in the morning. You wake up by 5, you are definitely will be sick.
Thank you. And finally, I think in one of the papers today, and since this COVID started, the issue of domestic violence has gained a lot of prominence. What do you see is the role of the CJ dealing with the problem of domestic violence?
Okay, domestic violence, I believe, is related to the family, not mainly husband and wife. Even children are affected by this violence. It's not a Chief Justice only problem, because those involved have to be arrested and prosecuted and the cases fast-tracked so that if one is convicted, it can send messages to those who are involved. There are already cases in court, people chopped off their hands and convicted. So the role of the judiciary and also of the CJ will be to ensure that whoever is implicated in this is prosecuted. But I'll have another angle to this.
Now, let me just ask, is there any of the hats you're wearing that focuses on this particular issue?
Yes, there is the hat of being the head of judiciary, and the hat of National Administration, Council of Administration of Justice, where other sectors in the criminal justice or the justice systems are involved. It can be discussed there. The CUCs, that's where I was heading. Sometimes you can see prevalence of an aspect of criminal law, and you go out and educate the people. I remember we used to have so many outer talks in Kakamega in conjunction with the county government. Cases of forest, people being charged with taking wood from the forest, will go near the forest and talk to them. The implication, the cases will reduce. So if, as the chair of the National Council on Administration of Justice, we can rope in the prison, rope in the DPP, and sort of sensitize the public that domestic violence is becoming rampant, and we should know how to deal with it. I think the CJ has a role there to play.
And finally, in terms of case, that same issue, what do you think, the same issue of domestic violence, now we have the COVID situation, we have operations of the courts have been affected. What kind of interventions would you look towards enhancing access to justice in that particular sphere?
We have had COVID, the courts are working, those arrested are taken to court. I know the prisons have been a bit hesitant to take suspects up to open court. We have technology. So as the CJ, I will try as much as possible to ensure that it has worked. All what we can do is to enhance the technology. It has worked. A plea can be taken from the prison as one sits in court, and the prosecutor is in his office. So it's not that we will relax. We will ensure that technology takes over and these cases are heard.
Thank you, my lord. Thank you, Chair.
Thank you, Judge. We are going well. Judge, you can have a sip of water. It's 2 hours. I will now request Honorable Commissioner Machadi Ajero to ask you some questions, and then after that you have Honorable Commissioner Evelyn Orwade to ask you further questions. Thank you.
Okay, thank you, Chair. My Lord, now let us start on this issue of jurisprudence and your legal philosophy. Now, I read this decision that you made on the Council of Imams and Preachers of Kenya in Malindi, where you were clear that a child cannot be married off because that would not be in line with the Constitution. You extensively made reference to the Constitution. Now, my first question would be that why I took interest in it, the fact that you are a Muslim yourself. Now, how do you handle matters that where your Islamic faith may necessarily not agree with the strict legal provisions of the law? How do you balance that out as you are applying the law, even as maybe sometimes you may not, it may conflict between your religion and what the law states?
I think the Constitution is clear that there is no state religion, so that's the starting point. So when it comes to making decisions, they should be purely based on the law. I'm sure there are certain aspects of the law when they will be brought to you, and you can see that on the one hand, the religion allows, on the other hand, the law says this. That was one aspect, and even at the back of my mind, I knew that those people who filed that case knew that I'm a Muslim, so let's go to this Muslim brother of ours and terminate this criminal case, because he will understand that from time immemorial, under the Islamic faith, a girl of 16 years can be married off. But my view is, first and foremost, you look at the law. And those who married off the 16-year-old girl knew that they are living in Kenya. In fact, I explained that when you are living in a country with the laws, the law comes first. Then the religion will follow. It's not that you are being restricted. You know, there are those issues like a law is passed, don't pray. That will not be law, because it will be contrary to the Constitution. The Constitution acknowledges the freedom of conscience. So no law will be passed that don't go for your Friday prayer. But when now these are purely personal aspects of saying a girl of 16 years can be married, I am a Muslim, it's true. In other countries where they don't have certain laws, like Kenya, where the marriageable age is 18, they exercise it. But I will go for the law, because if you go contrary to that, you will be setting a precedent that Muslims in Kenya can marry at 16. And I don't think that is the intention of the law.
Okay, thank you, Honorable Judge. Now, then that brings me to the second question of the issues of judicial activism, where there will always be a conflict between the three arms of government, each saying that this is my responsibility. And I want to specifically come now to the issue of legislature, because this is something that keeps arising, where the legislature will say that it's our responsibility to pass the laws, just like you've indicated. Then, on the other hand, you find a party who comes and challenges that law, and now becomes the responsibility of the judiciary to interpret. Now, oftentimes there's this conflict that arises that this judicial overreach. Now, what guides you as a judge, and what are your views regarding that? Because yes, the legislature sometimes will also overreach themselves in passing the law, but they'll say that we are the people's representatives, that's our responsibility. But again, now if the judge comes to a decision that seems to overturn that law that has been passed, again the legislature will say this judicial overreach. I don't know what are your views regarding it, and what guides you as a judge, and what to be your role as the leader of the judiciary if you are to become the Chief Justice in dealing with those aspects.
These are not gray areas. They have been with us. And the work of the judiciary is to interpret the laws as they are passed by the legislature. And the main focus here is the Constitution. The judiciary will pronounce itself that a certain aspect of the law is unconstitutional. There is, in my view, that is okay because it's the duty of the judiciary. We can't say that there is the general presumption that all the law passed is in compliance with the Constitution. But when it's analyzed, it's found that it is not. And it is the duty of the judiciary to punch holes to the law which is unconstitutional. However, we have had courts declaring certain aspects of the law as unconstitutional, but they still remain in the laws. I think there is need to come up with an approach. I have also said in the judgment, one of the judgments Commissioner Majanja referred to, one judge will say this is unconstitutional. Another judge says it's not, like in the aspect of Section 40 of the County Governments Act. So, what should the legislature say? Should they follow the one who says it's unconstitutional, or should they follow the one which says it is constitutional? So there is also need to come up with the areas, with the improvement on this declaration of unconstitutionality. It is true this is a conflict. It's not an overreach. I will not call it as an overreach. It's a responsibility, because the judiciary is there to interpret the law. But there is that need of finality, so that actually when we say this section of the law is unconstitutional, in my view, there should be an automatic picking of that declaration by another superior court, so that it can consistently be held to be so. So that I, as a single judge, does not say that a section of the law is unconstitutional, it's left like that, parties refuse to comply with that, yet maybe on appeal it would have been overturned. So there is, it's becoming a bit confusing, and also the Parliament might wish that why can't this aspect be cascaded to another court, so that there is that finality that actually this is unconstitutional. It's true, you can say there should be finality in litigation, but when it comes to declaring law which has been passed by over 200 legislators, I sit there as a single judge. It's true, I'm the expert in interpretation. I say so. Maybe three wise men would rule otherwise. There is need to manage this aspect.
Okay. Now, coming to that issue that you've just mentioned, where you have different judges coming to different conclusions, or even sometimes, and this is something that I've seen as a practitioner, for instance, in an employment court, where you find a decision has been made by a court of appeal clarifying a position, but still the employment court goes ahead and goes contrary to it. Now, I wonder, as a Chief Justice, in as much as it is not your responsibility to interfere with the decisional independence of the judges, but for purpose of enhancing kind of uniformity, or where this certainty, as is being said time and again, I don't know what steps you take as the leader of the institution to guide that, that process of creating certainty, where different judges are not making different decisions over the same issue, or Court of Appeal has pronounced itself, then you find judges are going against it, or Supreme Court has pronounced itself, then others are going against. I do not know what steps you take, clear steps.
Okay, thank you, Commissioner. As the head of the judiciary, because these things come to the limelight, they are not secret. We normally have the yearly colloquium where we discuss emerging jurisprudence. We invite one of us to discuss. So, first and foremost, to disobey what the Supreme Court has said, yet the law requires that all superior courts be bound by the decision of the Supreme Court, will be now to dwell on, cannot say impunity, but dwelling on something else. Equally, to disobey what the Court of Appeal has said as a High Court judge, and to say, these judges, let them say what they said, let me continue saying what I've been saying, would also be to ignore the issue of judicial precedents and the hierarchy of courts. Because why did this party appeal to the Court of Appeal? So to solve these problems, it needs, first and foremost, to bring together, like if we can have a colloquium of the Employment and Labor Relation Court, and tell them that you are creating confusion in the jurisprudence relating to this aspect of the law, and we deliberate on it and tell them that the Court of Appeal has guided you, so can you follow what the Court of Appeal is saying? Because it's not a matter of you can have your own personal views, but it is a requirement that you respect a higher court. So I would be engaging the individual courts and all the judicial officers, because the magistrates are ready to embrace what the High Court has said. Why can't the High Court and courts of equal status embrace what the Court of Appeal has said? And why can't the Court of Appeal embrace what the Supreme Court has said? So I would, we will now come, we can even have a catalogue of conflict areas. There are even conflicts in the Court of Appeal. I've seen, as I was in Meru, there is the issue of, under the Wildlife Act, if you are attacked by a buffalo, that act provides for a system where you start from a committee at the district level. But that process is not working, so people are going directly to the court. And there is a decision by the Court of Appeal saying you should start from that lower court, lower tribunal or committee, and there is another decision saying you can go directly to court. So these are issues of conflict, of application of the law, and they can only be harmonized. Maybe, like if it was a 3-judge bench of the Court of Appeal, if another issue arises, I would discuss with the president of that court to have a 5-judge bench, which can be seen to be more balanced and more pronounced, and rectify the situation. So I do agree that those instances are there, and it is for the judiciary itself and not somebody from outside to sort this one out.
Now, let us come now to your papers themselves, your qualifications. I saw you have an MBA. Now, tell me, and there's a reason why that will come out from my subsequent questions. How do you think this qualification would be useful in the institution if you are to become the Chief Justice?
Okay, I will answer that from my personal perspective. I took that MBA 1 year after I joined the NSSF. And I could see that we are dealing with finances, we are dealing with HR, we are dealing with ICT, and I have come with a background of the law. You sit in an investment committee where people are talking, investing in shares, investing in real estate, and you are there. All what you can say is you are giving legal advice. So the MBA becomes handy when it comes to dealing with issues to do with HR. It becomes handy to understand, because as the CEO of the judiciary, you will be receiving a lot of data, a lot of information from PMMU. It helps when you have to analyze the data. Like if I receive the DCRT of Commissioner Majanja, what has he been doing for the last 1 month? MBA enables you to analyze his data, how many rulings, how many judgments, how many witnesses have been heard. That is the simplistic aspect of it. MBA also gives you decision-making processes and how to make your decision, analytical aspect of your work area. So it is a crisp-cutting. Even the issue I've been asked, how will you bring together these judges and remove perception? Under the human resource management, things have to grind the way justice grinds slowly. You can accelerate, but if you are to move faster, you will break. Because if you become dictatorial, people will rebel against you. So the tenets of leadership are there under MBA, and I think it is a worthy cause for we lawyers to take, so that you know how to deal with people, you know how to deal with financial situations. I know as lawyers we do accounting at the law school, but that is basic.
Okay. Now with that MBA, I want to come now to the real issues that lawyers particularly have to encounter every single day in the judiciary. Let me start with the issue of automation, the digital platform that the judiciary is using. Now, I don't know what is your view regarding it, because whereas there's Zoom hearings, there could be Microsoft Teams hearings, and all that. But when it comes to interacting with the system, for many lawyers, it goes beyond that. There's the e-filing, for instance, which is difficult. There are always, every single day I can tell you that the complaints I receive are so many. I'm always, exchanging those complaints with the institution of the judiciary on behalf of lawyers. They can't even sometimes even print a receipt. They can't be able to file their documents. The system is down, And of course, the hearing is not just the hearing online, between the judge or magistrate and the lawyer. There's also the aspect of documentation. And it seems not to be working. So I do not know what is your experience regarding the complaints in that aspect, and what you do to truly, digitize the institution, and not to equate, online hearings with actual digitization of the systems within the institution. What steps would you take, using your MBA, knowledge?
Okay, I've had the same challenges because as you sit in court, you can't hear the lawyer on the other side. I will not blame this on the ICT staff. ICT is an expensive affair. I've interacted with that department because I'm somebody who wants to know why is the appeal not being heard, why at 10, after we start from 9, the systems go down. And they also have their answers to that. First and foremost, I think they are saying our capacity, what do you call them, is still very, small. There is need. When we were in Mombasa for a colloquium, we were taken through all this. They want to expand the capacity of the data center so that it can work, many users can punch in and it works. So that is a problem. Another problem is staffing. I've been told, and I've taken the personal initiative, that what we are using is homegrown. We didn't go to the market to buy a software which can handle our work. It has been developed from within by 4 developers. And these 4 developers, whenever there is the time down where there are difficulties, they have to be the same people who should go to firefight. They're saying they're not enough. And we need to invest in this so that we can have an expanded band. I think that's the word. The band is not big enough to accommodate many users at the same time. When every judge is there from 9 to midday, there is a lot of interruptions up and down. So the problem is known, and the ICT people are working on it, but there is need for the judiciary to recruit more ICT staff and expand the bandwidth. It's expensive because I've talked to them. They have that little knowledge. I can't say I'm an ICT expert, but they're saying even we are working at the mercy of international companies like Google, because when you have to go to Safaricom to allow you to use their bandwidth, you will be charged a lot of money. So that's why even the licenses, after every year, our licenses expire because we are using the ones given freely by companies like Google so that we can minimize on cost. So there is need to deal with this problem of ICT, because it is, in fact, it has changed the work format. Mentions, why do you have to drive from city center to Milimani to mention a matter? It can be mentioned online. An appeal where parties have filed submissions and they want to highlight. Why do I need them in court? So there is that need so that the virtual hearings can be real and compared to physical hearings, mainly in those aspects of the law where we can easily say an appeal can be heard. It's 20 minutes each. I will hear you. I have your submissions, and the system should remain constant until each advocate completes his submissions. So going back to the MBA, when you do MBA, I think you also do the information management systems, and you don't become an ICT expert, but it exposes you to how ICT can be harnessed to deliver justice.
Yeah. Now, for you as a judge, and I'm sure you've also interacted with your colleagues, do you have that ease of access and use of the system? Say, like if you want to access and get documents that have been filed easily, is it, is it a challenge, or is it something that you're doing very easily?
Okay, for now it's still a challenge, because I would sit in court and an advocate filed an affidavit of service yesterday, and you peruse, it's not there. And the court assistant will tell you, I have gone through the system and it has not appeared. So there are delays. So it is still a challenge. It's not easy. I filed submissions. They were filed 3 days before, but those submissions have not appeared in the portal. Or a lawyer wants to pay for a plaint, but the system is not picking. So it's not me alone. Everybody is complaining. But this thing became abrupt. I can't blame the staff. It became, nobody knew COVID will come in. So we have now to accelerate the system. It seems we ran against our time and enabled the lawyers to work when it was not yet ripe for that. So I can't blame them. They are really improving. But we can say, so far, it has assisted.
Yeah, so if you became now the Chief Justice, what are the key steps that you take to resolve some of these issues that cannot wait for too long? Because we need to be up and running, because they complain every single day regarding the user, the ability to interact with the system efficiently, where now what we thought is a solution is also becoming a problem in itself, without, of course, abandoning, because we can't go back. I don't know what steps you would take as the leader of the institution.
Okay. When you are asked to talk as the CJ, sometimes... Anyway, if I become the leader of this institution, ICT is already there. What is needed is to improve on it. So improving needs resources. There are certain aspects. I think that we have a whole ministry of ICT. I don't know whether I've not been working from inside, but from the little information I have, is that the ICT department and the judiciary management is engaging the Ministry of ICT. There is what they are calling the Ajira program, which they're trying to work with, so that the proceedings, they are recorded, and the Ajira program, they are given to the ICT ministry and produce the transcript. They have parameters so that you don't lose confidentiality. But to go back to this core issue of logging in of users and e-filing, it was launched very recently. We should not expect magic within this short time. So as the head of the judiciary, I would sit down with the ICT department, get down the requirements to improve on this. I know some of the requirements is that they are shortchanged. In fact, one of them told me that to procure an ICT thing takes a long time. The procurement process is very long, and the judiciary needs to ring-fence the money, the money which has been budgeted for ICT, because by the time the procurement comes through, this money has been used by other departments, because we are thin in resources. So they are saying it becomes a problem, and if you wait for next year, maybe that technology has changed. Now we have a new type of machine, which has to be, the one you are buying has become obsolete or needs improvement. So as the head of the judiciary, maybe I will ensure that whatever is budgeted for ICT, because it's becoming an important enabler of justice, is used within the ICT. I would even rather put off the construction of a court and expand on what ICT can do, so that it's not becoming, as we said, it was to enable us access justice, but now it's limiting to some extent. We want to reach where we wanted to go.
Yeah, because as you said, there's a significant number of lawyers who feel that the system actually is now becoming an impediment to access to justice. Now, burden of proof, because it's one thing to say that you'd be able to do all that in terms of providing leadership in that. Now, what is it that in your experience, when you look back at your background, because again I've checked right from when you're an advocate to NSF and all that, what is it in your background would make us believe that you've acquired these skills where you can be able to ensure that you're able to oversee the implementation of an efficient digital platform that serves the institution and, of course, the public at large?
I believe I should restrict myself to digitization, not to the wider aspect of the leadership.
Yeah, the digitization.
Okay, from my background, when you are a practitioner, our times there wasn't a lot of digitization. You have your computer in the office, and you use it to produce your pleadings and do your internal office management. I interacted with this ICT when I was at NSSF, and it's expensive. You have to buy systems which will enable each branch to log in and see the processes of the institution, working on the benefits of the retirees. Coming to the judiciary now, we have talked about ICT for long, to the extent that now it is becoming monotonous. ICT. The JTF, one of the pillars is ICT. They did their best, acquired, established the ICT department or directorate. SJT has come up with digitization as one of the pillars of SJT. So the totality, the burden of proof, which is the answer, is I know how ICT can improve the workplace. I know for sure it can. And the only solution to this is to talk to these people who are working on it. I remember at NSSF would spend millions, but when the instrument is bought, it doesn't work. You would go back to buy another one. So it can be an exercise in futility if you get it wrong. The beauty with the judiciary is it is homegrown, and but we need to buy certain aspects of these ICT instruments and cooperate with the ministry, and we will be there. I don't have to say that 100% when you take me, if you take me as the CJ, I will make sure that ICT will work in 100 days. You will be able to not to see these ups and downs. It boils down to the same thing. You have to make people agree that they are here to serve the wananchi, and they should do their best and improve on what is existing now.
Okay, I have three more questions. One, now you mentioned about the issue of backlog and sometimes delays in writing of judgments and all that, and I want to tie this to the issue of leadership generally. And you actually even said that the Chief Justice Emeritus did even write at one time a letter to all the judges telling them that, you know, you've to deliver judgments within this time. And many of them still didn't. Now, I'm just wondering, what is it that you do as a Chief Justice to make sure that when you do a communication, it is not in vain? It is a communication that will be followed through to, you know, with a view to ensuring that those judgments are indeed delivered. And if they are not delivered, that there are also consequences. Because again, if it's just an idle threat or a communication that is no follow-up or there's no implementation in terms of ensuring it's, you know, it's indeed followed to the letter, it's, you know, it's of no value. Now, what is it that you do as a Chief Justice to ensure that when there's a communication, when there's a directive, alive also to the fact that you are dealing with people who have security of tenure, they have their rights, but at the end of the day, again, there's the delivery of justice expeditiously?
My long-held principle is that you should justify the salary you get. You cannot be in this institution idling around, doing the bare minimum, and expect to get the salary from the taxpayers. So when it comes to that, the CJ Emeritus was very emphatic on this. He didn't issue mere demands and went to sleep. He would even follow it up for those who have not complied. He would follow it up, and he will even be calling them. Have you complied with this? I remember the office of the DCJ, where the ombudsperson is currently entrenched, would make a demand that can you comply with the letter by the CJ. So we'll put everybody on his toes when it comes to this issue of delayed judgments, when it comes to this issue of backlog, because backlog creates perception of corruption. That is for sure. Even you, if you have a case in court for 10 years and it's not determined, you might think that you have to go and bribe your way at the registry for you to get a hearing date. Commissioner Warsame dealt with the delays even in getting hearing date. But I can say we have improved. When we used to practice, by March the diary for the year is closed. You wait for January. But now in many courts you can get hearing dates for July, can get hearing dates for magistrate courts for August, for even for June. So as the head of judiciary, it will not be a matter of standing on top of Room 17 as commissioners referred it to, issuing demands that you have to comply and waiting for compliance, which is not forthcoming. I will be, maybe the main answer to this will be the PMMU, because that DCRT PMMU instrument can flash whoever is working and whoever is not working. The systems now can show how many judgments have you delivered, how many witnesses have you had this week. It can. So as the head of the judiciary, I will rely on this directorate that give me data for each and everybody, and it should be actual data, no raw data. I know sometimes you send the data and the station says you have given us the wrong information. Physically go there, count the files which the judge has delivered, judgments or rulings, count the backlog, and we are rated every year. They go around and assess what has been done. So I'll emphasize on that. And for those maybe who might be falling, you have a roundtable discussion with them. You are right, these are people with security of tenure, but security of tenure also calls upon responsibility. It's not a security of tenure in vain, whereby you come and say, I'm not doing anything, I'm not being supervised, I'm the presiding judge of the Nyeri court, I don't want anybody to ask me what I've done. You have to be responsible, and that is part of the code of conduct for the judiciary. You have to be responsible and deliver as expected.
You know, Honorable, my Lord, I'm asking this because these are some of the matters we are dealing with also at the JSC, where it has gone through that process you're indicating, but it reaches a point whereby the complainants now come directly to JSC. It becomes a complaint. So I'm still wondering that beyond the roundtable discussions, how do you as the Chief Justice ensure that indeed that it doesn't reach a level where JSC now has to deal with it as a complaint, when it could probably also be sorted out administratively?
Yeah, there are many ways we can deal. For instance, let's take an example maybe of a judicial officer who is performing below the average. A human resource will require that first and foremost you know his problems. Is it naturally an issue of laziness and refusal to work, or maybe this judicial officer has some social problems at home? Another issue is to discuss with the judicial officer for him to know, or her to know, that actually you are underperforming and you came here on the promise that you want this job because it's you who applied to get this job, and comparatively, because you are not working alone, there are 100 of you and the 5 of you seems to be working below average. I would also look at the aspect of maybe what is your specialty. Maybe you have problems dealing with the criminal law and you like to deal with family matters where the turnover, you can sign grants and hear objection proceedings and refer matters to mediation. So it's an all-rounder, but the bottom line is we want to uplift this judicial officer to the same level as the others. And what do we do if it becomes impossible, even with that stick? You are trying to propel the officer to those levels, but still you are not getting the results. I believe the question leads to that. What do you do? I think that's why we have the JSC here. The CJ does not have the mandate to send anybody home, but the law comes in and say you can be retired in public interest, because now you cannot perform. You are sick. You have told us you are sick. Maybe you take early retirement. Maybe because it can be a disciplinary issue. Because disciplinary doesn't mean the code of conduct is that you have to work. The idea of the code of conduct is that you have to work. That's why within the certain parameters, and if you are not fulfilling your obligations, then when do you pay you? JSC is paying your salary, and you are not working. I don't think it can be a hopeless case where we are saying we cannot deal with this officer. I think we can deal with those situations administratively, and if it is not working, we can escalate it to the JSC.
All right, thank you. Now, my final question. The key stakeholders in your understanding of the judiciary, if you could give me an indication of the three key stakeholders, and if possible in the order ranking in priority, and the reasons why you'd rank it that way, the stakeholders of the judiciary, you as the chief judge, that you would focus on in making sure that you satisfy them.
There are many, and to name three will just be to a tip in the ocean. But the key stakeholders is the public, because that's where we derive our authority from. So the members of the public are our main stakeholder, although this will encompass everybody. But as we sit as judiciary, we should know that we have been given this role by this public, who are the taxpayers. So I will give that as the number one. We are here to deliver justice to all, and all means the public. We have the judiciary itself has a stake in the judiciary, and by the judiciary I mean the staff, JSC. We are stakeholder by our own right, because we are here, we are working, we are earning. So the interest of the staff, the interest of the institution is also another component of being a stakeholder. The litigants who can come individually and through their appointed advocates, like the LSK, this is another stakeholder component, because it's a business also. It's a service industry. You serve the wananchi. They come to get justice from us. So the litigants are stakeholders. They want their cases to be heard, whether they have lawyers or not. They are stakeholders. We have the DPP is a stakeholder in the judiciary. He wants, when he charges somebody, his case, he wants it to be prosecuted. He's a stakeholder. The AG is a stakeholder on his own right. If the government has a complaint or has been sued, they want that case to be heard fairly, partially, and as quickly as possible. So the list is endless. The prisons are stakeholders. They want us to hear the criminal cases and finalize them, instead of having people put on the vehicles every day, brought to court, brought back to the prison. They are stakeholders. So the list is as long as I can say. The NGOs, they are stakeholders. They are people who are fighting for others' rights. As enshrined in the Constitution, the NGOs dealing with human rights, they are stakeholders in their own right. The business people. Why did we create the commercial court? The idea was to facilitate business disputes and hear them as fast as we can. But the commercial court has become just like any other civil court. Cases are taken there. They take as long as they can. So even that aspect of having a commercial court as to speedily hear these cases has been lost. So the businessmen involving banks, companies of whatever nature, they have a stake in the judiciary.
So how has your experience, your background experience, helped you in interacting with all these key stakeholders when you go back to when you became an advocate? And that's my last question, and I thank you, and I wish you well.
As I've said, the lawyers are a stakeholder. So I was a stakeholder in the judiciary, and I could see the many problems. As I've said, during our time, there was a call-over, monthly call-over. You go there, all of you in Court 1, and you allocated only 2 cases that month out of your 100 cases in the High Court. So my background knows that what the lawyer wants, whatever decision you make, whether he wins or not, he wants his case to be heard. So if it cannot also be heard, even hearing it is a problem, then that stakeholder has a problem. Another stakeholder I've interacted as a company secretary. If an institution has a case before the court, you as a company secretary, every time you go to the boardroom or the legal committee, they will ask you, how far has this case gone? If you give the same report today, after 4 months or 6 months, you go there, the case has been fixed for hearing. If you go there, it was adjourned to next year. So it defeats logic, and even it makes work impossible for some of these officers in the legal fraternity. Even the lawyer now, he can't get a hearing date. And if he gets it, the court is not sitting. So that experience gives me the background to know some of these pitfalls we may be having and how to fix them. So those are just but a few. Now, coming from within, I can see the numbers. Commissioner Warsame is right. Why is it that despite the increase of the numbers, still the work seems to be balancing? But the numbers of cases also have gone up. The statistics are there. Each year, what is filed is more than what was filed last year. So my background gives me that that knowledge of what an advocate feels as a stakeholder when he is told that these cases have been removed from the cause list without any explanation. They have been removed. And you have been waiting for 2 months to get it heard, but a day before you are told it has been removed from the cause list. There are good reasons. The cause list is 40 cases, but how did we reach there if we have electronic fixing of cases? Why can't we cap it, and when it comes for hearing, it is heard? So I know what the stakeholders are suffering, and I know how much we have done to satisfy them. Thank you.
Thank you very much, Commissioner Jero and Honorable Judge. I think to manage time, I would request Honorable Commissioner Orwade to tackle several areas, which is the conflict of interest, Commissioner Orwade, the corruption issues, and propriety and respect area together. Thank you.
Thank you very much. I don't intend to take a lot of time because a lot of the questions that I had have already been addressed. But just speaking on the last question you are responding to, my Lord. On the issue of the experience that you've had, you are one of the very few judges who have had experience in the justice system being on the receiving end of the services that judiciary offers. It is often said that it is the wearer of the shoe who knows where the shoe pinches. You were once charged in an anti-corruption case and you were eventually acquitted. But I would like to hear from you how that experience has enriched you and what insights that maybe you have gained that will be of benefit to the judiciary being on the receiving end of the services that we give.
Thank you, Commissioner. There is one document I wish I had laid my hands on. This is the report of the vetting board. I had that report when it was now giving the findings for every judge. And what you're asking me is there in that report. When you go through the process, you can see that there are those who are coming to this judiciary not to have their cases heard, but just to cause delay and maybe to embarrass or to serve outer purposes. But the judiciary should have that focus. Whatever case is brought in is brought for a good purpose, and hear it as fast as you can. My personal experience is we were two initially, me and the CEO, and two lawyers were enjoined who were handling the transaction. So the lawyer's intention was to delay the case, and they have filed an application to stop the hearing of the criminal case. And I have my ruling with me here, where I had to go to the Court of Appeal and say, because the late Commissioner Camino had granted them the orders that the prosecution should stop. And I had to file an appeal because I was not involved in the application. My view was, can I be heard? Can the public know what I stole, what I took, so that this issue is settled? So thanks enough, the Court of Appeal agreed with me, and we went back, and the two of us were heard. And we were up to the last level, 35 witnesses, no case to answer. So this experience makes you know, like if you read that report of the vetting board, if an accused comes before you and raises his hand, hear him.
Just take your time, Honorable Judge.
It's good you have asked some of these questions. Okay, I know what people have to be prosecuted. That is the mandate of the DPP. But as you sit as a judicial officer, you should be able to sift out what has been brought for serving other purposes and what has been genuinely brought as a court case. And I'll give an example, like granting bail. I can't understand why a court will take a whole month to grant bail or deny bail. You'd rather even deny so that this party can go to another court. But if you take two weeks, the spirit of the Constitution is that nobody should stay indoors. I agree, there are those cases with compelling reasons. If we have people charged with terrorism, you can't just grant them bail. There are heinous offenses which are committed. You cannot grant bail. But sometimes I can't understand why somebody charged with the corruption offense is a whole governor. Can he run away, surely? And if he will, are we not having any ways of bringing him back? And the case the bail application takes a whole month. Maybe the governor is in custody. That is, it's not that because a governor is maybe well paid and whatever. Even the simple cases, why should somebody charged with assault stay indoors for 1 week, yet the magistrate is grumbling with whether to grant or not to grant bail? So as you have said, it's the wearer of the shoe. I've gone through this process. I have to appreciate that mine cannot be said to be a bad example of the judiciary because the case was heard within 1 year. Thanks to the magistrate, she was very industrious to hear us, It was a corruption case which the law allows to be heard on day-to-day basis. But those who bring you to court will develop cold feet. And that's why I was saying we have a few magistrates in Nairobi hearing these cases, and they're overwhelmed. It's not that they're lazy, they're hard-working magistrates. But why can't the leadership of the judiciary decentralize these cases so that we know if you are charged with a corruption case, you are from coast, the idea is if you are from Mombasa, your supporters will come to Mombasa court and start singing, we take you to Lamu, or we take you to Garsen, and the case is heard as fast as... I'm sure that magistrate will be having that one single case with 40 witnesses. Within 1 year, that case can be heard. It's not that the system is bad, but there are ways of perfecting it. And to answer your question, maybe I'm taking longer than expected, but I have this experience. I know where the judiciary can improve. I know the judiciary is not the only player in this system, because if you are within, you can see this person has just been charged to facilitate maybe the riots, somebody was killed, and they had to arrest somebody and bring him to court so that the situation can calm down. So as a judicial officer, you should know why, or if maybe you release this person out of bond, you will be killed. So there should be that aspect of knowing what to do with a certain aspect of some of these cases. When I was practicing, the issue of delays in the judiciary, you can't get a hearing date. The judges were few. They were working, but still the numbers were overwhelming. So, Commissioner, I can look this institution from either ways. I can look at the judiciary from the eyes of a lawyer. I can look at this judiciary from the eyes of the stakeholder of business people or business institutions like NSSF, where I was, where you have cases which are never ending. They are never ending. Your lawyers are raising fee notes every time they mention cases. I can look at this institution from within, having stayed here for 12 good years.
Thank you very much, Judge, for that response. My next question will take us back to the Martin Charo case that you already you've been asked about from a different perspective, though. Often, when a judicial officer is working or handling a case, you find yourself in a situation where the law kind of conflicts with your personal views or your personal sentiments on the subject at hand. I'm looking at the Martin Charo case. I've read the decision, and one gets the impression that in that judgment you are dealing with several aspects of our sexual offences law that have generated a lot of debate. The age of consent, the minimum sentences, the defense of reasonable belief that the victim is above 18 years old, and even the Romeo and Juliet clauses. And one gets the impression that your sentiments, your personal sentiments may not be in consonance with what the law provides for. So what I want to hear from you, Judge, is what do you do in scenarios where you find what you believe as a person conflicts with what the law provides for?
Actually, it's not that the judgment is contrary to the law. That would be a narrow interpretation or looking into that judgment. As Commissioner Majanja has said, maybe the hue and cry is maybe the communication. That is another aspect of looking at it. So the several aspects, the age of consent, it's not that I'm advocating for the reduction of the age of consent. in another judgment, I tried to explain, I think even in that one, how other countries have the age of consent, some as low as 14. But the issue is not even the age of consent. The issue is, I'll go back to the question by acting CJ, the social aspect of the law. Is the law serving the people, and how do we interpret it? Because also it's an issue of interpretation. If I were to operate that when the ingredients of defilement, age, the action, and identification, and go to prison, I don't think that is the duty of a judge. The issue is you have to analyze what transpired. So the age of consent to me is not an issue, but my issue is also the minimum sentences, because as a judicial officer, having seen an 18-year, until recently, an 18-year-old, a 17-year-old boy with a 17-year-old girl, the boy goes to prison. Until recently, when I think one of the judges said they all could not consent and acquitted them. So this minimum sentence to me is a problem, because it ties the hands of the judicial officers, and it is contrary to the aspect of independence of the judiciary, because the judicial officer is the one who is hearing this case. Because compare the Martin Charo, assuming I was wrong and I was to convict, can you compare Martin Charo with somebody who violently pulls a young girl to the bush and defiles? Yet all of them get the same sentence. In the case of Martin Charo, these are people who have been dating. Even they went to the parents' home and slept there for 3 days. Even the brothers knew where their sister was. So can you say because the law provides minimum sentence, everybody should suffer the same fate irrespective of the circumstances of the case? I don't think so. So the minimum sentence should, Murwatetu case has come up with the aspect of murder, but I can see it being applied across all other cases. Reasonable belief that the minor was...
allow me to interject, please, because I've been made aware of the time. What I wanted to get from you is in instances where you find your personal views are conflicting with the law. You've already given us your perspective concerning the minimum sentences. You've given us your perspective concerning the fact that the law does not necessarily take care of the scenarios that you're talking about, the scenario where someone has violently attacked a child and sexually violated them, or where a child is cooperating, which in my view covers the Romeo and Juliet scenario. So what I'm asking basically is, when you find that there's conflict between what you feel or what the beliefs you hold as a person and the law, how do you treat that scenario? Thank you, Judge.
Okay. I don't think by writing the judgment I was enhancing my personal feelings. There are no personal feelings there. All what I'm saying is the law should serve the society, and that normative aspect, positivism of applying the law the way it is, I'm not in favor of that. What I'm saying is the law should serve the public, and it's not that I'm imposing my personal views that it's my interpretation of the law. It might be taken that by interpreting the law, it's skewed towards my personal views, but to me, it's just my honest interpretation of the law that under Section 8.5 and 8.6, a judicial officer should look at the circumstances of the case. The word circumstances is there in those provisions. Look at the circumstances of the case. Do they exhibit an aspect of defilement, or they exhibit something else? And since the law does not give you the leeway to say, although there was an aspect of, you can call it even defilement, but the circumstances are different. I'm imposing 2 years. People will say the law does not provide for 2 years, or are putting this person on probation. Then you have to interpret it wholly and see this was not defilement.
Thank you very much, Judge. My next question is, do you think that the consequences of a decision should be of concern to a judge when a judge is handling a matter?
When you're handling a matter, you are dealing with a specific problem there and then. Definitely, each judgment has consequences, but it all depends on how you are looking at these consequences. If you are too timid, I can sit there as a judge. Whatever appeal comes, I dismiss because the magistrate did good work, and I will not be in the limelight. So, if you are consequences-oriented judicial officer, you have no place in this judiciary. The consequences should guide you to effect the law so that the society will be able to know what aspects of the law is. So consequences, you can look at them, but it's not that maybe people can say, Saidi wrote that judgment without taking into consideration that women might think that he is against them. No. One aspect of this role of a judicial officer, I don't know whether it's impartiality or propriety, is the capacity to be independent and make your decision as per the facts and as per your interpretation of the law. The consequences, whether they will be hue and cry, they can be cured by other people. If the matter go on appeal, let them even dress you down. But to me, this aspect of independence, of making your decision, it's inbuilt. In fact, I have no issue sleeping over a file for like a week. I don't know what else. If I read your file, I look at it. It's not that I hastily make a decision, but with the experience, you just make your decision. The consequences can be positive, they can be negative. But if you want to be popular, you are seated there, just sitting on the fence, not making decisions which may have negative impact on you, then I don't know. But to me, the negative consequences are also admissible. So it's true you can look at the consequences, but does it shape are you saying something which is contrary to the society? We can't sit here and say young girls and boys are not engaging in this thing. The COVID problem, we have seen many girls sitting for KCPE when they have just delivered. It's a social problem. So me, I am not saying that I don't know the society. I know the society. And I'll give you an example. A lady appeared before me in Malindi with a kid. She's a witness. And she was 17. I looked at her, she looked younger. So I was wondering whether to do the voidaya or not. But I see she has a child. So I asked her, how old are you? She said, I'm 17. It was a murder case. I think a relative had been murdered. So how did you get the child? She told me, this is my second born. When did she get the firstborn? So this is the practicality of the law. So people can sit and give you an unnecessary award, but this is the reality. Go there on the ground. You have seen it. You convict a 20-year-old boy, the 17-year-old girl is crying, where are you taking my husband? These are the problem of the society. Those are the consequences. Now, do you look at the law and say, go to jail, Or do you look at this girl who will turn 18 next year and be free to get married? And maybe they have a child. What do you do with this child? Who will take care of the child? I can give as many examples taking care of time. In Marsabit, a young girl who was in Form 3, she was defiled by a boda. They had a child. The family knows. Even they got married. One day, the father goes to the child, to the boda to ask for money for milk. The girl is in school. This boda is a young man, he's playing pool. And he tells him, Mzee ngoja nimalize hii game. This is his father-in-law. The Mzee gets annoyed, goes to take his daughter from school, straight to DPP's office. He's charged and is convicted. He comes before you. 6 months down the line, the reality has dawned on them. The girl is not in school. The child is not getting support. As a judicial officer, they go to the DPP now to plead that can we reverse this thing? We didn't know it will go to this because the girl was around 17 and a half. So we are dealing with the actual problems on the ground. We are not dealing with the law in abstract that you see penetration, you see age, you convict. No. I can give you as many examples as possible. The law in practice.
Thank you, Judge. Your point is made, and the examples suffice. Maybe if I can ask you a last question, now that I've been told to cluster all my areas together, not everyone is good at everything. We all have our weaknesses. Can you identify one weakness that you have, Judge, and what you have done to try and correct it?
It's very difficult to criticize yourself, but we are human beings. We are not machines. When you are set, there you go until when you are put off. We all have our strong elements and weaknesses. I think some of the strong elements can be turned into weaknesses. Maybe one can say I'm too generous when it comes to sentencing. Having, as you have asked, having gone through the processes, and I've seen it myself. Wherever I go to a court, those in prison are very happy because they think they will get a moderate sentence from me. But I've been firm. If I look at your file and you did something not worthy of being in the public, I will deal with you. So there is that aspect of witness, of seeing somebody from a social aspect of life, that every person can be reformed. I remember when I was in Malindi, in my entire practice, I've sentenced only 2 people to death. Yet the law, even before Murwatetu came. So there is that aspect in me, believing that even the worst of a criminal can be reformed. I am not against the death penalty. It's a good sentence. At times it's worthy passing. So that can be one aspect of my weakness. Another weakness I can tell you is maybe it's a strong thing, but also another weakness. I tend to believe in what you are telling me for some time. I consider that whatever you will tell me has some elements of truth, but later on I have to analyze. So I'm not a person where I can dismiss you. There are some situations where you have to dismiss somebody. The moment he opens his mouth, you know he's lying and you dismiss. But I have that weakness. I have to listen to you. So even if you are lying, you have taken the religious text, but you are lying, I will leave you to talk until the end. Although it's part of our work, but sometimes There are those who will cut you short, and then what happened just to discourage you to know that you are not interested. Maybe it has taken me as a surprise. I didn't know that I will analyze myself. Maybe another weakness is overworking myself. I believe in finishing what comes. So that ends up in making yourself sick. It is a weakness because one should program himself and see how to manage your time. But I've learned how to do that, how to manage your time, how to balance between work and life. I think I'm now up to task.
Thank you very much, Judge. That will be all for now.
Thank you very much, Commissioner Orwade. Now I would request Commissioner Honorable Attorney General to ask both questions related to independence and also the relationship between the different arms of government. Thank you.
Thank you, Chair. My Lord, you touched on the aspect of judicial activism, if I may ask you this, just to tie up one or two loose ends. And I presume over the years you have formed your own thoughts and impressions on the subject. What would those thoughts be? And how do you see judicial activism shaping the future of the Supreme Court in this country?
Thank you, Commissioner. Judicial activism can be both subjective, objective. It depends on how we view it. At times, the judiciary is being accused of encroaching on other spheres of other arms of government. With regard to the Court of Appeal, Supreme Court, maybe there is the view that it is taking jurisdiction which it doesn't have, in the process actively making itself a bigger and wider institution in form of jurisdiction. So in the eyes of the Supreme Court, I cannot say that there is no judicial activism, but in my own view is that at times that activism is necessary to solve a problem, because the activism is not generated within. It's the law, is the cases which are filed there, which needs interpretation, and in the process of interpretation, a court can be seen to have been doing judicial activism. But I don't think it's a wider aspect of what is happening in the courts. And I don't think we can say that the Kenyan courts are now, instead of dispensing justice, exhibiting judicial activism to the detriment of their core mandate. So to answer you, Commissioner, as assuming I'm there in the Supreme Court, all what will be my concern will be to deal with the issue at hand within the parameters of the law, and not to be seen to be stepping on the toes of others in advancing judicial activism. I don't know whether I've answered you.
Thank you. But with your knowledge, my Lord, of the Supreme Court over the last 10 years, this elasticity that you're alluding to, in what instances, if you were Chief Justice and the head of that court, in what instances would you encourage your colleagues in that court to exercise this activism?
This can come in different forms. For instance, the interpretation of the Constitution, which is a core mandate. That court is supposed to interpret the Constitution to give it meaning and purpose. What did the Kenyans want when they came up with this interpretation?